Hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we are going to have a discussion about whether or not you should have a will and a trust, whether you can have a will that has a trust inside of it, whether you should have a will if you have a trust. There's a lot of interesting questions about this interaction between wills and trusts, right?
Well, it's kind of like wills or trust didn't replace wills. Maybe they inside of will, but like I guess the question that a lot of people have is, if you have a trust, why do you also need a will?
Well, and I think the first thing to ask ourselves is, what is a will?
Yeah, so a will is a super simple document. Anyone out there who thinks I have a will that's probably going to get it done, it's probably going to accomplish all my goals. Yeah, you're probably wrong. Depending on what your goals are, you're probably wrong. But all a will really does is a will names who gets your stuff after you pass away, and that encompasses anything in your personal name. So anything in your personal name, a will just says, here's who I want it to go to. Now, with the caveat, after a prolonged, expensive probate, most likely, a will, and I don't know
if it's considered to be valid.
If it is.
So the first thing that happens in probate court is you are checking out with the court to determine whether or not they agree that this is a valid will.
Right.
There are at least 5 requirements in the state of Wisconsin for a will to be valid. And if any one of those boxes are not checked, then you have an issue. So that's why, as much as it appears to be a simple document, it is not. And there are lots and lots of wills that we have reviewed here that are invalid.
Right. It's what I like to call it, it's a short document, but not simple.
Packs a punch.
It certainly does.
Yes.
And what's really sad is that it's not a simple document, and a lot of people screw it up. And even if you get it all right, it still won't do what you most likely need to do in the world of estate planning. So that's pretty much what a will is. I mean, a will at its general core, it's a letter to the judge that says, here's how I want you to do my probate.
Now, let's talk about something that's a little bit of a twist on this. A lot of times there will be this question, can I have a trust inside of a will? In other words, the will gives instructions to open up a trust after I pass away. That is called a testamentary trust. And that is something that is valid in the state of Wisconsin. And basically the terms of it say, I want the court to move all of my assets into a trust that will be overseen by the probate court, so that my beneficiaries receive what it is that I want them to receive within the context of this trust. Okay. So the question is, why would you have that kind of a document? I can tell you why you would not. You would not, because it's basically functioning in 2 different ways. One is you're going to probate court, and then you're asking that probate court to oversee the trust administration. So it's literally the most expensive and most complicated way of handling your estate administration. So that's a good reason why you would not want to do a testamentary trust. Can you think of any reasons why you would want to do a testamentary trust?
I mean, I was just going to ask you that. I don't know. Maybe you would only do a testamentary trust if you don't know living trusts, if you don't know about revocable, irrevocable trusts, and this is, you go to an attorney and this is all that they do.
Yes.
Other than that, I cannot think of a reason why you would do that over a living trust.
I concur.
Okay.
We've never done them here,
No.
And I don't think we ever will, because it really defeats the purpose of having a trust. So then the next question is, if you have a trust in place, then why have a will at all?
Great question. So the reason being is because in the world of estate planning, we work a lot in the realm of what if. What if this happens? What if that happens? Because we want to try to cover all the bases. That's the whole point of having a plan that is comprehensive, okay? And as part of the comprehensive plan, we never give someone a trust without also giving them a will. But what's cool about the will is going to change forms. If anybody out there has ever heard the term pour over will, I'm pouring my heart and soul from this will into my trust. What the pour over will says is that if there's anything in my personal name at the time that I pass away, that pour over will is going to catch it and it is going to pour it over into the trust, because the trust is going to have many, many, many pages about here's how I want all my stuff to be distributed. But what if I forget to put something in the name of my trust?
Mhm.
What if I pass away and a check is en route in my name,
From Uncle Johnny, who died and is now giving you $1 million.
who evidently was a prince in France
Yes.
and had all this money?
Yes.
Yeah, exactly. There's a check made out to your name, but not the estate of your name, and so, or you just have an account and you forgot about it. I know a lot of people. They have a different job every 2 years. They open up a different HSA with each job, or a different 401k, and then they just forget about them. And so it happens to
Yes,
people.
it does.
And so
Yes.
if you think about it like a trapeze artist, the trapeze artist may have the harness on so that they don't
Mhm.
fall, but there's also a safety net just in
Mhm.
case it doesn't work. The pour over will is that safety net. It's going to catch whatever's in your personal name and say, look to the trust to how I want this item distributed.
Yes. The caveat being that if that safety net needs to be used, then you're involving the probate court.
Right.
Because there's no way that you can take a pour over will to a bank and say, "Hi, bank, here's a pour over will. Could you please pour this bank account that my father would not put into the trust before he passed away, and just dump it into the trust? Will you do that?" The bank will call the big bad lawyers in New York and will say, and you'll hear, okay, that's what you'll hear when you're in the lobby. And they'll put down the phone and they'll say, we need some letters of administration from the probate court in order to do that. And so, what does that little magic phrase mean? Well, it means that a probate needs to be opened up, a probate action needs to occur, and that asset needs to go through probate before it will pour into the trust. So that's the problem, is that it is a good safety net, but the safety net has its costs associated with it if it needs to be used. So what's the lesson from that?
Is do your best. Try to put as much, all the stuff that you're aware of in the name of your trust, because yeah, you don't want to rely on the safety net. I don't want to rely on an airbag.
Right.
Should I get in a car accident, I want to rely on my seatbelt.
Mhm.
Okay, and so we don't want to rely on that safety net because there's still a probate, and that's the whole point of getting a trust set up, is to avoid probate. And so when you have when you have the trust set up and you also have a pour over will, you know that I'm going to move all of my assets into the name of my trust. If I forgot anything, if I'm due any money, that is going to be, maybe there's a probate, but that's going to be distributed per my trust instructions. And what makes this so darn important, Kirsten, is that let's say you have specific instructions in your trust. If we've made many videos about, if you're a blended family, you have specific instructions. If you have no kids and you're leaving it to nieces and nephews, those are specific instructions. You want to make sure that any money due and owing to you gets divvied exactly how you want.
Yes, exactly. And there, believe me, we have had plenty of situations where people have come in only with a trust and not with that backup pour over will. And that's a big mistake. That really should not be a situation that somebody finds themselves in, because if there is no pour over will in place,
Yeah, what happens?
then what happens? Well, that's going to probate, and then the probate court does not have instructions to put it into the trust. And so then you're opening up an actual probate where the intestacy laws will apply. So let's suppose you have 5 nieces and nephews that you want to leave everything to in your trust, and this asset does not make it into the trust, and there is no pour over will, and you pass away. Now, who are those assets going to according to intestacy laws?
If you're not married, they're going to your parents.
Yes, and then if your parents have passed away,
Your siblings.
Your siblings. That's exactly right.
Yeah.
So that is the course of events. So it is very important to have either a simple will or a pour over will in place. Those are extremely important, so that then they're interacting with the trust appropriately. And just one more word about wills.
Mm-hmm.
Have a will. Even if you're 20 years old and you think you don't have any assets and you don't really have anything going on in your life, if you don't have a will, it just makes life so much more complicated. So we are more than happy to do simple wills for people who are just needing that solution given where they are at with their asset development. But it is really important to at least have that in place.
I agree.
So thanks so much for joining us. We are here for your today and your tomorrow, and we will see you next time.